All right, good afternoon, everybody. Thank you for joining us today for a discussion about some ongoing COVID issues that we're seeing facing many of our clients. So we hope you find this presentation educational. My name is Brad Keaton. I'm a partner in the Louisville office of Stahl, Keene & Ogden, and I'm going to be discussing some issues today related to PPP forgiveness, especially focusing on the forgiveness process for loans of $2 million and greater.
Hey folks, my name is Mark Hurst. I'm the beardless fellow in the picture currently on your screen. I am also a business litigator, but as most of you know, in Louisville, Kentucky, that can run the gamut from a lot of different angles. So I see a lot of different types of litigation, some of which have been implicated by COVID-19, particularly when it comes to contract work and force majeure clauses. So that's going to be the portion that I share with you. Brad, do you want me to go ahead and address some of the housekeeping items?
Sure, please go ahead, Mark.
Yeah, just need to let everyone know that this is a recorded session and the video is going to be edited and posted on our SKO YouTube channel. And then following the webinar, for those of you who are interested in CLE credits, you'll be sent an email with both the Indiana and Kentucky activity numbers so that you can claim your CLE credit. I'll provide you with a reminder about that at the end of the presentation. And then last, we will circulate a brief Survey Monkey that all of you have received before. We'd really appreciate it if you just took a minute to fill that out so that we can get feedback on the content, the presenters, and anything else that you found interesting or not interesting. Thanks.
All right, thank you, Mark. So one of the things that is required for CLE credit in Indiana is that there is an interactive portion to this. So for that reason, we're going to do a pretty brief poll. I want everybody to know that your responses are confidential. I can't see who is answering what, and the individual results won't be shared with the group. It'll just be sort of collected results. So I'll open the poll, give everybody about 30 seconds or so to respond. Okay, so looks like a couple of people on here did receive a PPP loan. Most have had or have submitted their forgiveness application. Most have already received approval from the SBA. Okay. So as noted before, I'm going to be talking about the Paycheck Protection Program, loan forgiveness, and giving some updates on some things that have happened pretty recently, do have some effect on the forgiveness process. So let me start by talking a little bit about sort of the original treatment of PPP loans. And as I said before, in particular, I'm going to focus on loans of $2 million or greater. What we saw, so I'm going to talk about the necessity questionnaire that came out, the loan forgiveness process, and in particular, the review of large loans. I'm going to talk briefly about a lawsuit that was instituted that challenged some of those forgiveness procedures that the SBA instituted. And then I'm also going to finish by talking about some changes that came about around July of this year. And those include the discontinuance of that necessity questionnaire. I'm going to talk a little bit about what the forgiveness process seems to be right now, and also a little bit about what the SBA's general audit authority is. So start briefly with just an overview of the Paycheck Protection Program. So it was part of the March 27th, 2020 CARES Act that most of us are familiar with. It provided 100% federally guaranteed loans to small businesses to fund payroll and some related obligations. Used for approved expenses, the loans could be and may be forgiven in full. Subsequent to that, as we all know, there have been a lot of changes to the program. So it's kind of been a moving target, an ever shifting landscape as to sort of what's required for the loan, what the sort of covered period looks like, what forgiveness looks like, and other things. It's been a lot of work to try to pin that down. Again, I'm going to focus today primarily on the forgiveness process. So anybody who submitted an application for a PPP loan had to make a certification, and that certification is really what has created a lot of the uncertainty and a lot of the changes that we've been seeing. So that certification is there at the top of this, and the certification was that current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. So I think this is a good time for everybody, especially those who did receive a PPP loan, to think back about what your mindset was in the spring of 2020. The pandemic had just started. States were issuing various forms of closure orders or suspensions, and there was just uncertainty. There were some industries at that time that could predict with some clarity what COVID was going to do to their business. For example, the restaurant industry. That was one that was pretty clear once it was forbidden to go into restaurants that was an industry that was going to suffer. We all knew that. But for most industries, uncertainty is exactly what it was. Nobody knew how bad things were going to get for their business, for their industry. It was so early in the pandemic when the CARES Act came about and the program started. So, a lot of employers were contemplating, even before business had taken a downturn, in anticipation of that possibly happening. They were thinking about laying off employees, reducing pay, taking other measures. And again, this was in anticipation of bad times to come. But again, nobody knew how bad it would get for them or for their industry. So I think keeping that mindset is important and understanding as we walk through this process. And so once the PPP loan started to be issued, pretty quickly there was a lot of controversy. Some of the big names that led to this, the Lakers received a PPP loan. Shake Shack received a PPP loan. There were reports of publicly traded entities that were owned largely by hedge funds. So well-capitalized industries receiving PPP loans. And that created some controversy out there. And in April of 2020, former Treasury Secretary Steven Mnuchin issued a statement that really made a lot of people nervous. And so that statement was, to further ensure PPP loans are limited to eligible borrowers, the SBA has decided, in consultation with the Department of the Treasury, that it will review all loans in excess of $2 million, in addition to other loans as appropriate, following the lender's submission of the borrower's loan forgiveness application. So again, that was roughly 1 month after the PPP loans began. And all of a sudden there is this target on the back of anybody who took a loan of $2 million or greater. And in fact, one of the operative sort of guidance documents throughout this process has been a frequently asked questions document that the SBA has maintained and updated, I believe, 8 times or so, 8 revisions or so of that document over the course of the pandemic. But they pretty quickly issued a new FAQ soon after Mnuchin made that comment. And that FAQ said, do businesses owned by large companies with adequate sources of liquidity to support the business's ongoing operations qualify for a PPP loan? And the response pulled a piece of that out, but it is unlikely that a public company with substantial market value and access to capital markets will be able to make the required certification in good faith. So that was sending a message that, look, if you're well capitalized, if you're publicly traded, if you have large investors, there's a good chance that you don't need this loan. SBA also created a safe harbor period that got extended a couple of times, but basically said, if you return your PPP loan in full by this date, we won't look into you anymore. We'll just let things go. And a lot of companies got scared. And I'll be honest, a lot of companies that fully deserved the PPP loan and companies that did it by the books still went ahead and returned the money because they just got nervous about what all this would mean. So then in the fall of last year, this dreaded sort of loan necessity questionnaire was issued. And again, thinking back to what we talked about at the start of this, which was that the name of the game the loans started, again, was uncertainty. That was the certification, was uncertainty. But this questionnaire was extremely sort of forward-looking in nature, right? It wanted information on how, in fact, did your business do from the time you took that loan, right, throughout the rest of 2020? How did things end up being for you? Were they as bad as you thought they were going to be? So there were, some of the things that were looked into. There was a comparison of Q2 2020 gross revenue with Q2 2019 gross revenue. So what was your middle of the pandemic revenue versus your pre-pandemic revenue? They wanted information about whether you voluntarily were not shut down, suspended, or restricted operations. They wanted to know about any expenses incurred for those sort of shutdowns or restrictions. And then there was this liquidity assessment. So they wanted to know the cash and cash equivalents as of the last day of calendar quarter immediately before the PPP loan application. So what kind of money did you have on hand before you submitted your application? Did you issue any dividends or capital distributions between sort of the start of the CARES Act and the end of your loan forgiveness covered period? Did you prepay any debt during that period? Did you comp anybody in excess of $250,000 on an annualized basis? Any parent subsidiaries, including foreign, again, as I mentioned before, so were you publicly traded? Are you owned by a private equity firm, a venture capital firm, or a hedge fund? So they were really diving in on, again, how did you end up doing? So it was less focused on what were the reasons that you sought the loan in the first place, and more about, in hindsight, did it turn out that you needed that money? And again, that wasn't really the purpose of the CARES Act. The purpose of the CARES Act and the PPP program, PPP loans, were to prevent you or to help you not have to cut salaries, lay people off. Because again, companies were going to do that in anticipation of things getting bad. And if it turned out they didn't get bad, fine, they may rehire those people, reinstitute those salaries. But by that time, the harm had been done. And so that's what the CARES Act was meant to prevent. But what the SBA ended up doing is looking for ways to say, you didn't really need this money, it turns out. And they made it pretty clear that that wasn't dispositive of whether you were entitled to the loan in the first place, but it would be a factor that they would consider during the forgiveness process. So as I mentioned before, we have these frequently asked questions. And I'm going to walk through just a couple of them these are pre-July 29th of this year, and I'll talk in a minute why that's an important date. But 39 was, will SBA review individual loan files? And they say yes. And in particular, again, and this kind of mirrors Mnuchin's statement from April of 2020, which is, they say, in consultation with the Department of Treasury, they will review all loans in excess of $2 million in addition to other loans as appropriate following the lender's submission of the borrower's loan forgiveness application. I want to highlight that word review, and I meant to do that when I commented on Mnuchin's statement. But there's been a lot of talk about audits by the SBA, that all loans over $2 million are required to undergo an audit by the SBA. I just want to highlight the fact that the SBA and the Treasury Secretary never use the word audit. They use the word review. I think that's pretty important as we walk through this. So fact 46 said, how will SBA review borrowers' required good faith certification concerning the necessity of their loan request? And again, so they remind you of that certification that you made at the time you submitted your PPP application. And again, state that, well, so this is this basically the safe harbor that they created for smaller loans. And so what they're saying is that for loans under 2 million, there is a presumption that you made that certification in good faith. For loans of $2 million or more, there is not that presumption, right? And so there is going to be this additional review by SBA. And then we had fact 53, and it's a long one. I won't read the whole thing, but the question was, why are some PPP borrowers receiving a loan necessity questionnaire? And again, so SBA says they're looking for eligibility, fraud, or abuse in compliance with the loan forgiveness requirements. And so they're giving that necessity questionnaire to all borrowers with loans of $2 million or more. And that information will help SBA assess their necessity. That certification that's referenced there is the necessity certification. So again, SBA is saying, we're going to look at your questionnaire responses. We're going to see how you ended up doing, and we're going to determine, we're going to consider that as a consideration as to whether you made your original necessity certification in good faith. Now, they do note in there that the certification is required to have been made in good faith at the time of the first draw PPP loan application, even if subsequent developments resulted in the loan no longer being necessary. So they are saying, if you did okay, it doesn't necessarily mean that you shouldn't have taken the loan. But again, there was a lot of uncertainty, a lot of nervousness around these statements, these facts, and that necessity questionnaire. And they say there that this targeted multi-step approach will ensure the integrity of the evaluation process and expeditious processing, as well as properly allocate SBA's finite resources to those first draw PPP loans that require additional review. All right, so as of that point in time, really up through, I'm going to say July of this year, what was the SBA's review process? So in April of this year, the GAO, General Accounting Office, issued a report. And the report was titled, SBA has begun to take steps to improve oversight and fraud risk management. And it was interesting because the SBA had really never gone into a lot of detail about what their internal process was for reviewing forgiveness applications. But this GAO report provided, shed some light on that issue. So step one, and this is one that every loan, no matter of the size, had to go through, and this is an automated review. So the SBA contracted with an outside company. They created a proprietary tool to screen every PPP loan. Then for loans so if the automated tool flagged something in there, the same contractor then conducted a manual review of that loan. And they decided whether it was unresolved, meaning there were indications of noncompliance, fraud, or abuse, or resolved, meaning that, at least from that contractor's perspective, things were fine. Then you go on to step three, for loans of under $2 million. At that point, SBA would only conduct a review if the contractor noted that the loan status was unresolved. However, for loans of $2 million or greater, SBA will, at the time, stated that it would conduct a manual review of every single one of those loans. That is the review that Stephen Mnuchin was talking about. That is the review that the facts are talking about. And it's the review that has sometimes been referred to as the so-called mandatory audit of the larger PPP loans. And then there were some quality control reviews that would happen as well. So the one of the things that I think sort of precipitated the changes that I'm going to talk about in just a second was this lawsuit that the Associated General Contractors of America brought. It was filed in December of 2020 in the U.S. District Court for the District of D.C. The AGC, if you're not familiar, is a very, very large trade association in the representing general contractors. And so they sued the SBA and also the U.S. Office of Management and Budget. And they were challenging that necessity questionnaire. And it was really on two bases. The first was really sort of a technical challenge that related to kind of the review and comment period that the federal law requires. So there was an argument that the agencies didn't comply with that. But they also argued that the necessity questionnaire and the fact that it was forward looking, that is, looking at what happened from the time you sought the loan, and not what were the reasons that you sought the loan when you did. You know, there was an argument that completely went against the spirit and really the law of the CARES Act and the regulations that provided for the PPP loans. So again, that was brought in December of 2020. The agency sought an extension of time to respond in a subsequent pleading, and made this comment that I thought was interesting. It said the government is undertaking a policy review that may materially bear on the claims in this case. Additional time is required to complete that review and engage in attendant discussions with plaintiff. So there was a signal there that that pleading was made in, I believe it was January or February of 2021. So there was kind of a signal there that, all right, we're looking into this. There may be something to this. Ultimately, that case was settled and dismissed on August 4th. Now, we're not privy to the settlement agreement itself, and there was no real indication of the settlement terms in the actual dismissal filings. But there has been, speculation, and I think probably pretty well supported, that it was that lawsuit, that challenge, that largely prompted the changes I'm going to talk about. That the SBA just realized they had overstepped, just wasn't worth the fight anymore. So what happened after that? Well, on July 29th of this year, there were some pretty material changes made to those frequently asked questions, in particular the three that we talked about before. So 39, again, we talked about that before. Will SBA review individual PPP loans? And so the pre-July 29 versions of that FAQ, we looked at this before. SBA opened with this sort of reminder about the certification and stated its intent to conduct this kind of additional review of all loans in excess of $2 million. And so now we see that answer has been changed. It now read, for a PPP loan of any size, SBA may undertake a review at any time before or after SBA remits a loan forgiveness payment to the lender in SBA's discretion. So any specific sort of carving out of loans of $2 million or greater for this additional scrutiny is gone. Then we go to facts 46 and 53. And as a reminder, 46 focused again on SBA's intent to review all loans in excess of $2 million. Again, focus on that necessity certification. Fact 53 was the one that dealt with, why did we issue the loan necessity questionnaire? And so those were deleted entirely from the July 29 version of those facts. They were deleted because, again, decision was made by SBA that larger loans, $2 million and greater, would no longer be treated differently than loans of a smaller size. And SBA decided to discontinue the use of the loan necessity questionnaire. And they added this new fact 69. And the question is, why is SBA discontinuing use of the loan necessity questionnaire? Now, no specific mention is made to that AGC lawsuit. I still maintain that I think that was sort of the thing that really got them to change their tune on this. But they did know that during some of the comment periods, the comments were basically overwhelmingly against the use of that questionnaire for a lot of the same reasons that we've already talked about, which is to say, the intent was what's in your mind at the time you made the loan. That's what goes behind that certification, not did you end up doing okay. Nobody could predict how they were going to end up doing. So the necessity questionnaire is discontinued. So what does the review process look like now for loans when forgiveness application is submitted? Well, of course, at first it goes to the lender. Assuming the lender approves the forgiveness application, it then gets submitted to SBA. Again, no more loan necessity questionnaire. By all appearances, all PPP loans, regardless of size, are being treated the same. So what appears to be the process now is all loans go through that automated review tool that we looked at before. If there is no flags in that process, the SBA approves the forgiveness, move on. If that tool flags it, then it does go through the manual review process that we talked about before. So first, if there's a manual review by a contractor, if the contractor notes it is unresolved, it would still go on to SBA for a manual review. Now, you've gone through the process pre or post July 29, you've received your forgiveness. Are you necessarily done and out of the woods? Unfortunately, the answer is no. The SBA does still have the authority to conduct audits in concert with the Office of Inspector General. The SBA issued a interim final rule on February 5th that stated that recipients of PPP loans of more than $150,000 must retain all relevant documentation for 6 years after the date the loan was forgiven or repaid in full, and must permit authorized representatives of SBA, including representatives of its OIG, to access such files upon request. So, I mean, the advice that we're giving to clients now, regardless of the timing of your forgiveness, if you've received your forgiveness, you must maintain all records related to that loan and its forgiveness for the full 6 years from the date the loan was forgiven. Does it mean that you're going to be audited? Absolutely not. What I think is probably the case, I mean, I think SBA now is focusing on clear instances of fraud, of abuse, of entities that really shouldn't have taken this loan in the first place. Those are the entities that are likely to undergo that kind of process. And there's probably a random component to it, the same as there's a random component to IRS audits. There's a possibility that somebody just randomly gets selected for an audit of their SBA loan process. But that audit authority is not specific to PPP loans. That is the audit authority that's inherent to the SBA with regards to all of its various lending programs. So you need to maintain the documentation, but the chances of an audit or an additional review once you've received forgiveness is probably very, very slim. So with that, I will kick it over to Mr. Hurst for his discussion of force majeure issues.
Thanks, Brad. Before we go on, I did have a quick question for you. If I'm going to say a company's forgiveness application went through the more rigorous review process before, I think you said the date was July 29 or 30, does that decrease the likelihood of an SBA audit during that window you mentioned?
Yeah, I mean, I think that's a good question. I mean, I would say this. I think that entities that had the larger 2 million plus loans that went through that more rigorous review process, I think I would tell them in the event that they are selected for an audit later under the SBA's general authority, I think it's probably going to be a smoother process, because by that point the SBA we know SBA has done a manual review. That's without question. We know that SBA has reviewed the loan necessity certification. So by that point, the automated tool didn't flag anything. The SBA's manual review didn't flag anything. They looked at the necessity questionnaire that's no longer being used. They may have even asked for additional documentation. That's something the SBA can do. So by the time you get to that audit, the question is, what really else are they going to look at? Because they've done that deep dive on it. So I think that if you are sort of randomly selected for an audit, it's probably going to be a smoother process. Whereas if it's, you go through this post July 29 process, which is much less in depth, and there won't be a manual review unless the automated tool selects it, your audit may be a little bit more detailed and a little bit more rigorous, because the SBA hasn't already seen a lot of that information that it would have seen had it been before July 29.
Do we know, and sorry, and I'll move on to mine, but I do have a question. Do we know if as companies are audited, is that kind of information publicly disclosed, or has that been made known yet as to whether or not there's going to be obviously I recall there's some publication of who secured their PPP loan, but will we have available public information about who is audited, after the fact in that window?
Yeah, I mean, I think that's a good question. I think the answer is I'm not completely sure. I think if you would have asked me that question a couple of months ago, when we were all sort of operating under the belief and the understanding that, there really was a target on the back of those with the larger PPP loans, I would have said that, yeah, I think they probably will be fairly public about what they're doing with those additional reviews or those audits, it really, as much as anything, to appease the public, and that help that perception that this program was just rife with fraud and abuse. Now, I mean, I really do think the tune has changed, and unless there starts to be sort of, I mean, I think the press coverage around these programs and what's happened, that press coverage really has died away. Nobody's really paying much attention, right? There's no, I mean, the process, you can't get a PPP loan now. The second draw is closed. A lot of people are going through the forgiveness process. So I think unless the media sort of latches on to some extraordinary cases, there starts to be a discussion again about whether this program was handled appropriately. Unless that happens, I think the answer is no. Now, general information on who SBA is auditing, very well may be subject to an open records request. So I mean, it's possible that somebody could do an open records and get information on who is being audited or who has been audited. But so far, I'm not aware of that happening. And again, the coverage has really died down. I mean, we kind of expected that there, pre-July 29, that really there may be a lot of litigation that comes out of this. People submit their forgiveness application. SBA looks at the necessity questionnaire, says, you did really well in 2020. It turns out you really didn't need this money. We're gonna reject your forgiveness, and that there would be lawsuits that would come out of that because of the way they've changed the way they're doing this, and don't seem quite so focused on that issue. The real issue for them now, I think, is actual fraud, abuse, things like that. I don't think we're going to see the kinds of litigation that we expected to see arising from this. I know that was long-winded, but I hope I answered your question there somewhere, Mark.
No, you did. I know our clients hope that. Okay, thanks, Brad. I appreciate it. All right, folks, we will transition to the COVID-19 force majeure portion of the presentation. And I think we'd be hard-pressed with this audience to find many of you that gave thought to whether or not a contract, whether it's for one of your clients or for your business, whether or not that contract had a force majeure clause in it. Or if you saw it in the contract, it wasn't something that you were negotiating on or likely concerned with. From my experience, contracts are most frequently negotiated on price, schedules, penalties, specifications, the type of goods. But let's be honest, how many times has the phrase act of God come into play in the operations of your business? I mean, the phrase itself, I would leave it to attorneys to create a phrase in contracts that results in the question of whether or not something was an act of God, to be something that we have to wrestle with. I mean, practically speaking, we're not going to have an opportunity to ask him if this action was caused by him. But when we talk a little bit about the genesis of this term, you'll see where it stems from. And it really comes down to performance of the contract and whether or not something like impossibility can serve as a defense. But the fact is now, in the present circumstances with the pandemic, variant D, whatnot, you'll be hard pressed to find a business, I think, that has at least, you'll be hard pressed to find a business that has not had to consider force majeure clauses. So for today's purpose, we're going to just briefly touch on the history of the force majeure clause itself. Where did it come from? A general discussion of its meaning, which I think most of you all are familiar with. Then we'll briefly touch on COVID-19 and its impact on force majeure clauses, both in negotiation and in operation, including, just touching on some of the industries that have been heavily impacted by COVID-19 when it comes to discussion of force majeure clauses. Then we'll delve into what I'm going to call a case study on force majeure. And that involves a case that our firm handled for our client, Steel Plus, which is actually an organization out of Canada. Andy Hagerman, who is with our office, did a wonderful job preparing dispositive motions on an issue that we actually prevailed on. And so we want to talk about that because while we can read up on what law firms are saying about force majeure and how they might be interpreted, it's nothing like having an actual court decision. And it's a Jefferson Circuit Court decision. It's not something from our Court of Appeals, but that notwithstanding, it's still very interesting to see how a court would rule on these issues. And then kind of in wrapping up, we'll talk about, well, what if you're in a current contractual relationship where there isn't a force majeure clause? We'll talk about that, including some tips for negotiating the force majeure provision itself, as well as how to deal with your operations in the face of force majeure issues. So kicking it off from for the history buffs, I'll say the principles behind force majeure clauses actually originated in England when a court decided that circumstances beyond the control of the two contracting parties excused performance under the contract. That's a fancy way of saying two parties agreed on something, and then it effectively became impossible for one of them to perform for no reason of their own or no fault of their own. And so in that situation, there was an event organizer who had contracted with a venue owner to rent a music hall for I think 4 days in the summer of 1861. So we're going back quite a bit in time. And the event organizer agreed to pay the venue operator a sum of money the day of each event. But before the first event could take place, a fire destroyed the entire music hall. Now, the parties, unlike in today's world where any contract of any substance is going to have a force majeure provision, back then, in fact, I'm going to say all parties' contracts did not have a force majeure provision. There wasn't anything in it of that nature at that time. And so what the court did was it evaluated the contract, and it determined that the purpose of the contract was to permit the event organizer to use that specific music hall. And so without the hall itself, the contract was impossible for one party to perform. And so in reviewing prior English cases, the court summarized the rule as follows, and I'll read from the decision, which was in Taylor v. Caldwell. The court said, in contracts in which the performance depends on the continued existence of a given person or thing, a condition is implied that the impossibility of performance arising from the perishing of the person or thing shall excuse the performance. And so without the concert hall, the performance of both parties was excused. And, you know, again, particularly 160 years ago, courts are going to articulate things in probably a little bit more sophisticated legalese manner. But basically what it means is when the two parties contract and it becomes impossible for one of them to perform, you're not going to require performance, or in this case, require them to pay damages. So fast forward 20 years later, the Supreme Court of the United States adopted the same rule of law. In a case called the tornado, which actually has nothing to do with a physical tornado, it has to do with a ship named the tornado, the Supreme Court concluded that the owner was not required to deliver freight on his ship as contemplated by the contract because his ship had actually caught fire. Apparently, 160 years ago, they had a lot of trouble keeping fires away from ships and music halls. And so because this happened before the ship was due to transport the goods to the buyer, the ship caught fire. And because the contract said that the goods would actually be delivered by that ship, the tornado, and that ship was destroyed, the Supreme Court adopted the rule from Taylor, providing that the owner of the ship's performance was excused because it was impossible for him to perform. So that is a very brief history of the force majeure clauses. I think most of you would consider them just to be a basic standard term in the contracts. But what they do is they effectively allocate the risk between the parties in the event that performance becomes impossible. Now, we'll talk a little bit more about negotiating these clauses, but keep in mind these provisions are construed narrowly. In other words, the court is not going to give them an expansive construction or interpretation. And so when you think about that from a negotiation standpoint, if you're planning on wanting to take advantage of a force majeure clause, and I would submit that most of you all can't predict the future. If you did, you'd probably be in Las Vegas and not in your business. But you know, in the position of the relationship, which party is likely to need to rely on a force majeure clause. Let's just paint the basic picture of an owner of a construction project versus a supplier. in that dynamic, most likely it's going to be the supplier that has some concern over the force majeure clause. And in that situation, the supplier is going to want to be as inclusive as they can in drafting it to make sure that the force majeure clause is grabbing as many situations as possible. On the flip side, if you're the owner, you're going to want that force majeure clause perhaps not even included in the contract, or you're going to want to limit it as much as possible. Now, let me be clear, you don't have to have a force majeure provision in your contract to take advantage of the defense of impossibility, and we can talk about that a little later. But it would certainly put you in a better position, particularly in light of the pandemic. And I alluded to the language from that case from the 1860s, but I mean, the standard language for a force majeure clause provides something along the lines of no damages shall be due for a failure of performance occurring due to acts of God, war, natural disaster, terrorist acts, government regulations, and any of those that make performance impossible. And that's something we're going to talk about in the case study. It's not just enough that there's a triggering event, it has to make performance impossible. In terms of industries and the relationships that are impacted by COVID-19 and force majeure, there has certainly been an uptick in litigation associated with COVID-19. And let me, as a litigator, we watch the case filings that come into our court systems. That most areas are down for the past year in terms of the types of filing. Personal injury hasn't taken a big hit, but on balance, most types of litigation are down except for those related to COVID-19. And most of those, surprisingly, or maybe not, are employment-based. Those have revolved around compelling attendance of employees and requiring vaccination. For a business litigation lawyer, I'm always looking at business litigation disputes. And of course, before this presentation, did a search to see if there are many publicly reported decisions on COVID-19 and force majeure, and there just aren't. But I think most of our clients are very concerned about these, and I have probably fielded, say, anywhere from 25 to 30 calls over the past year about these provisions, and have had to help clients navigate sometimes the contract renegotiation and sometimes the termination of a contract. What I think happens in the commercial industry, if you will, as opposed to personal injury law or employment law, is that businesses often find a way to work around the issue as opposed to filing something in court. In terms of industries impacted, I don't know if any of you are in the construction industry, but that's something that, that's an industry that's really been hit hard by COVID, but also those relationships are just fraught with peril when it comes to the force majeure provisions and how they interact with COVID-19. And so you could have the owner who wants to have a very limiting force majeure provision with a general contractor, but then you can have a general contractor who wants to have a very expansive interpretation of it when it goes upstream, but not such when it goes downstream. So it just depends which side of the table you're on. Entertainment industry has been hit hard, and COVID-19 has impacted that, as well as the travel industry. And both of those are implicated in the case study that I want to talk about. So the case that I want to mention is called Schneider Hotels versus Steel Plus. And everything I share with you is public record. So I'm not, concerned about sharing any secrets or anything, but I do think it's an interesting take on how courts view COVID-19. And before I go any further, let me say this. Nothing that Brad or I discussed today in the form of commercial litigation or PPP loans is intended to overshadow the human tragedy that has been suffered by millions worldwide. It's a disaster of epic proportions, and we as lawyers are trained to have to be well versed in these issues for our client, but they certainly take a far back seat to the human side of the equation. So in the case of Schneider Hotels versus Steel Plus, I think most of you know, if you have any connection to Louisville, that Schneider Hotels owns the Gold House. It's Louisville's largest hotel. And most of you, if you've ever been involved in event planning and I feel sorry for you if you were in some respects. You know that these contracts with venues often have termination provisions that, hey, you're booking this event 1 year out, but if you're within 6 months, 3 months, you still have to pay a penalty. And on balance, those are typically enforceable because the parties were negotiating for that right. Steel Plus was the client of our firm, and they contacted us about litigation. It was actually potential litigation when we got the call. Steel Plus is a buying group in the steel fabrication industry, and they're located in Nova Scotia, Canada. 54 of their 54 members are located in Canada, and that's going to come into play later. So in October of 2019, Steel Plus entered into a contract with the Galt House. It wasn't a big contract. It was for 50 rooms for 2 nights in April of 2021. So we're talking about 100 rooms, but also part of the contract was a minimum for food and beverage. And so that added some value to the contract. And in the grand scheme of things, it's not the kind of contract that would make or break most companies, but to a steel organization, it was not a small amount of money for them. And so the contract had a cancellation clause along the lines of what I just mentioned that said, in the event of a cancellation occurring 181 to 365 days prior to the arrival, liquidated damages in the amount of 70% the contract price will be due by Steel Tech Plus taxes and service charge. Contract also had a force majeure clause which read, no damages shall be due for a failure of performance occurring due to acts of God, war, terrorist acts, government regulation, and any of which makes performance impossible. So there's that two-prong approach. It's got to be an act of God or something else listed in the force majeure provision, but then it also has to make performance impossible. Well, we all know what happens next. By January of 2020, the U.S. reported its first COVID case. I don't want to take you all through the brutal history, you know it, but in terms of how this was impacting Steel Plus's approach to this, by May of 2020, there were approximately 8,000 confirmed cases in Kentucky and over 1.6 million infections across the U.S. On the government side of things, Government Andy Beshear, and I think the first one was March of 2020, he said that only 10 people can gather in a single location. And I think he reinstated that again in July after slowly backing off of it. And so don't forget, Steel Plus is a Canadian entity. The U.S.-Canada border was closed to non-essential travel on March 2021 of 2020. And so if it was essential travel, you could travel, but then you still had a quarantine for 14 days. And so from Steel Plus's perspective, their gathering was going to be in violation of Kentucky law on the gatherings, and also either risk violating U.S.-Canada border laws if they came to their gathering, because they were going to be bringing more than 50 people, and it likely was not essential travel. So Steel Plus notifies Galt House around May of 2020 that it wants to terminate the contract. There's some back and forth about the liquidated damages provision, and as a result, the Galt House sent Steel Plus an invoice for 70% of the contract price, including the rooms, banquet food and beverage revenue, taxes, and service charges. Now, those of you that have ever been in a contract dispute, you're familiar with the concept of mitigation. That's a party's obligation to reduce their damage exposure. Well, the Galt House was sending this invoice 330 days out from the date that Steel Plus was due to occupy the rooms. So we always felt like we had a mitigation argument. Interestingly, neither the mitigation argument or the liquidated damages argument was given much discussion by the court ultimately. I come to realize as I talk through this presentation with you all that I'm not likely to receive any free rooms from the Galt House, but I'm not criticizing their behavior in any way, shape, or form. If I was representing them, I probably would have advised them that you do have a right to pursue it, but the right's likely subject to challenge. So the Galt House filed a lawsuit against Steel Plus in Jefferson Circuit Court before Judge Angela McCormick Bissing. Anybody who has litigated in the past 2 years in Jefferson Circuit Court has heard of business courts. They're designed to resolve disputes between businesses. There was no discovery in this case, so no questions asked, no depositions taken, in part because the question of whether or not the contract is read in favor of one party or another is really up to the court. And so after filing their complaint, the Galt House moved for summary judgment based on the contract language. They really made two primary arguments, and I'll try to stay out of the weeds, but on the one hand, they argued that the liquidated damages provision was enforceable and that Steel Plus stipulated to its reasonableness. The other argument, the one that received all the fanfare, was the force majeure clause, and Galt House took the position that it does not excuse performance for a couple of different reasons. One, they said that COVID-19 was not an act of God, and the other was that the contract could still be performed because we could pay the 70%. In other words, because they had contemplated this very situation, we could perform, and therefore the contract should be enforced. We filed what's called a cross motion for summary judgment and presented our own arguments. And this is what was prepared by Andy Hagerman from our firm. And I'm reminded of something one of my old mentors said. If I drafted the brief, my mentor would say, well, you briefed us to success, and I didn't mess it up with my revisions. And that's really the case here. This was Andy Hagerman's brief. He did the research, put it together, and did a wonderful job. And the contract, so our argument was that the contract's force majeure clause excuses Steel Plus's performance, and we did this by design. So again, I'm going to geek out on the argument approach, but we decided not to make the liquidated damage part the first part of our argument. It was focused on the force majeure clause, and we said the virus was an act of God. Black's Law Dictionary defines an act of God as an overwhelmingly unpreventable event caused by the forces of nature. Now, Wuhan conspiracy theorists, might take issue with that, whether or not COVID-19 was caused by a force of nature. But as I'll mention in a little bit, that's what our judge ultimately hung her hat on. We also addressed liquidated damages, and where we actually thought we might have the strongest argument was the virus-related government regulations. We said that those regulations, because of the language in the contract, actually constituted a force majeure event that excused our client's performance. You had the border closing, you had the limited gatherings, and so to perform, you essentially had to break law, or at a minimum, quarantine for 14 days afterwards. Judge Bissig issued an order on January 28th, 2021, and I should have. Maybe we can send you all a link, but the order was 9 pages in length, and obviously we were happy with the outcome. It concluded that our client, Steel Plus, should be excused from paying the damages provision. And interestingly, there was nothing in the court's opinion addressing liquidated damages, solely focused on force majeure. And then in the context of force majeure, the court was only interested in discussing the act of God and the fact that this was a natural event. So we never got into whether or not the government regulations triggered the force majeure provision. From a business lawyer standpoint, my perfect opinion would have been that the court gave us both. But the court noted that COVID-19 was a natural event. It was not foreseeable by the parties, and therefore it was an act of God, and that we, Steel Plus, were excused from performing. So there was, we were surprised that the government regulations weren't addressed, but at the same time, we were happy with the result. No appeal was taken by the Galt House. So it's not, if you're a practicing lawyer, you know that you have to, you prefer to have a Court of Appeals decision or something from the Supreme Court of Kentucky. We don't have that here, but I can tell you if I'm litigating a dispute like this again in Jefferson Circuit Court, I would certainly be bringing this order to the court's attention. So heading down the home stretch, some tips for negotiating. First, know which side you're on. I'm not saying you want to spend a fair amount of time negotiating a force majeure provision, but if you're on the receiving end of goods in a supply chain relationship, you're not going to want that force majeure provision to be overly expansive. You're going to want the other party to have to perform, so you're going to want to try to constrict it. But I will tell you that all of the new contracts we're seeing that are between, I don't want to say fairly sophisticated parties, but parties that have a reason to have a multi-page contract, COVID-19 and other pandemics or epidemics are really, it's boilerplate language that's being included almost, because they don't want to just limit it to COVID-19, because heaven forbid in 2 years we've got another pandemic that's not called COVID-19. So recognize whether you want that term to be expansive or limiting. And also, if you're in an operational standpoint, so you've already got a contract and you're not going to renegotiate it, recognize as early as you can if it will come into play. We have had a number of clients call us and explain that they are anticipating demand or supply issues with demand due to force majeure. They can't get the materials they need. So just start mapping out your strategy as soon as you can. Of course, seek the advice of counsel as needed. And then one thing you cannot overlook is notice requirements. And I know that that's probably relevant to any contract defense that you're trying to raise, but you don't want to send an email when certified mail is called for. And so if you don't have a force majeure clause in your contract, obviously you could attempt to renegotiate it. But if things start going badly for you and you're the party that's supposed to be performing and can't, we always have what we call the impossibility, the defense of impossibility, and that's something that we could always fall back on. So that is force majeure in the face of COVID-19, at least as it relates to what we have seen in our firm. But I know that many other law firms out there have good material if you look online, and we're just constantly monitoring this because every case is so unique. And so we within the firm are constantly communicating about, hey, let us know if your client had a force majeure issue come up. Let us know how it was resolved, because a lot of times these are resolved out of court and we just don't have much to hang our hat on. If there are any questions, I'll take them. If hopefully I have not put you to sleep just yet after your lunch hour.
Thanks, Mark. I have one question, and you touched on this some in your remarks, but could you elaborate a little bit on sort of the difference between force majeure and impossibility?
Sure. So in its most simple form, force majeure means you've got a contract term that you're pointing to that accounts for acts of God, war, terror, whatnot. The impossibility defense, it's not in the contract, so to speak. I mean, you could put it in there, but it's not required. And that's invoked when the subject matter of the contract, like in those early 18 or the mid 1800 cases, when the subject matter of the contract's been destroyed or something has been destroyed that the parties would have relied on for performance. Force majeure is not intended to excuse negligence of the parties, and then impossibility is not applicable in situations where the action is self-induced. In other words, you create the impossibility. Force majeure is a defined boilerplate clause. Impossibility is typically not defined in a contract. It's a defense that even if you don't look at your contract and have something that mentions COVID-19 or mentions force majeure, you still have an opportunity to demonstrate the impossibility defense. But we would recommend, kind of a two-pronged approach. Definitely have your force majeure provision in there, and don't forget you also have impossibility as an option.
Anybody else have any questions for Mark or for me? We're got another minute or two left here if anybody has anything.
Again, following the webinar, you'll be sent an email from our marketing department with both Indiana and Kentucky activity numbers so you can claim your CLE credit. And then if you can, please just take a minute to complete the survey in the email. And Brad and I are both grateful that you all showed up today, and hopefully you learned something, and look forward to interacting with you at some point in the future.
Yeah, thanks to everybody for being here. And if you have any follow-up questions you didn't want to ask on this, feel free to reach out to Mark or I individually. We're talk. So thanks, everybody.
Thank you all. Bye-bye.